and thank you all attending for joining us for Internal Investigations 101. My name is Dan Cotter of Ehrenberg Golgan, and I am your moderator today. This webinar is part of the Financial Poise webinar series, Corporate and Regulatory Compliance Bootcamp. Slide 8 of your slide deck, and we will not be going through the slides, but you have them, provides a summary of the series. And slide 7 summarizes this particular episode about internal investigations. And we're not going to read it, but again, you have it there for note-taking and for posterity. Episodes in this series and their live debut dates are listed on slide 9 of the slide deck. Speaking of the slides, you should understand from the get-go that we will not step through the PowerPoint in order, nor will you have to listen to us read any slides. This webinar, like all Financial Poise webinars, is a conversation, and you're in for a treat today with the two speakers that I'll introduce in a minute. Keep the PowerPoint handy, however, because I will try to indicate what slides our conversation is touching on as we proceed, so you can take notes. But again, the slide deck's not overly long, and you'll have plenty of opportunity to dig through those as our panel goes through the questions that we've prepared for discussion today. Our panelists today are Braden Anderson and Stephanie Bustamante. And again, my name is Dan Cotter. We appreciate that you're not spending your time and money to attend this webinar to hear infomercials about us. You can read more about us starting on slides 43 to 46. The webinar is a production of Financial Poise. To sign up for the great free weekly newsletter, go to www.financialpoise.com or shoot an email to info@financialpoise.com with the word subscribe in the subject line. If you are attending the live premiere of this webinar, you can submit questions using your web portal. If you are watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar episode, and we will do our best to get you an answer. Financial Poise webinars are supported in part by sponsors. The sponsors for this webinar are listed in our slide deck and include our co-producer, National Law Review, which is on slide 3. Thank you also to our sponsor, Max Asset, which is on slide 4, and the disclaimer is on page 5. With that, we're going to start asking some questions here as soon as I can find the questions that I have put together, and give me 1 second here as I go through my pile here. So welcome, and we're going to go through a number of questions with our two excellent panelists, and we will start. Let's start with a basic introduction. And Braden, why do internal investigations matter?
Yeah, I think depending on the industry that you're in and the size of the company, they matter in different ways. I think as outside counsel, you tend to see the importance of internal investigations matter more as you grow in size, right? As a small startup, it's always important to practice good corporate hygiene and corporate governance strategy. But I think the larger that you get as a company, certainly as you become a publicly traded company, when you start looking at companies that operate in highly regulated industries like the financial industry or the securities industry, the consequences of having poor financial hygiene or not knowing when to initiate an internal investigation and when that tool is important to be utilized, the consequences and the risks and the liability that comes with that just become more and more severe, right? But I think if you look at where we are today, we can all think of a couple, examples in mind, right? Enron, right? Or others where you had something awful that happened that was a crisis for that company. But we also had an example just recently, right? With the CEO at the Coldplay concert, right? These types of crises for companies can occur in such a wide variety of different ways that we're going to get into, obviously as we go through the materials. But I think thinking about these investigations as a tool for accountability, as a tool to mitigate risk, and protect the company's reputation is a big thing. But I also think if you're an executive team and if you're a board, right, it's also about insulating risk. It's almost an insurance policy, because when you have something that happens of a certain level of severity, right, or if you're just questioning the level of severity and how material this is, and how as a company you need to respond to this, it's really invaluable to have an independent third party, set of eyes from another organization come in with fresh eyes and be able to give you the clear answers of exactly what happened, exactly what needs to happen moving forward, and what the recommendations are. And then you're kind of safe to take that recommendation, in the form of an investigative report, and make the decisions that you need to make moving forward. But I'll pause there.
Yeah, and I should mention the real treat that you're in for today with this webinar, as we prepared and got to know the two panelists, is Braden brings a private practice perspective and outside perspective to the mix, and Stephanie, who you'll hear from in a second here, brings the in-house perspective. And one of the things I think that Braden mentioned already is that when it comes to internal investigations, the reality is that a lot of companies really don't understand kind of the flow or the importance of it. As he mentioned, having an independent third party come in sometimes, people can be too close to it depending on what level within a company it is. And we'll go through some examples. He mentioned Enron, but there's one of the places that this surely comes up for a lot of companies these days, is think of, if you're not really familiar with the internal investigation process, kind of think of the data breach scenario. It's not really an internal investigation, but it's a form of it, right? You immediately call outside counsel, and then you start digging in with forensics teams into what happened. And it's a similar type of thing, but these are in other arenas. So Stephanie, let's turn to you. Braden kind of talked about why they matter. What are the most frequent ways that an internal source can trigger an investigation?
Yeah, so I mean, I've seen them come in through all various sources, and it probably differs a little bit from my perspective as in-house counsel than for Braden as outside counsel. And maybe Braden, you can jump in. But from my perspective, typically, by and large, the way that internal investigations at our company are handled come in through our hotline. So it's either via calling, employees will call the hotline, or they will submit a report via our website. And both manners allow them to make these reports anonymously if they choose to. Of course, we always hope that they choose to disclose their identity, because it really makes it a lot harder when they are anonymous. And then, of course, employees will often go straight to their manager and say, hey, I saw this issue, or I heard this issue, or this happened to me. And then, either their manager, or a lot of times they'll also go to their HR business partners. And in either case, then you're really sort of relying on the communications that you've made to mid-level managers and all the way down, all the way below them, so that they know that they should escalate certain matters, right? Not every single matter needs to be escalated, but most companies will have some sort of escalation protocol so that managers and HR business partners will know, okay, at a certain level, this is serious enough that we need to escalate it. And by company, I think it varies on where they should escalate it to. And then sometimes employees will also directly contact the legal department. So at our company, we have a shared mailbox that the general counsel of the company monitors. Now, that is possible with smaller companies, let's say 10,000 employees and under, right? And then at bigger organizations that I've moved into, they don't necessarily have that, but they do have like a just an email for for legal, that someone kind of varies on who, but is responsible for monitoring. So sometimes employees will go that way. And then the other way I've seen internal investigations triggered is through audits. So often, actually, I would say maybe 20% of the cases of internal investigations that I've seen have come up through audits. And it could be any type of audit. So an internal audit, either most companies or larger companies will do some sort of FCPA or anti-bribery and corruption audit, financial audits. I know at my previous company, they did internal audit, conducted quarterly corporate credit card audits, and that generated a lot of triggers. Some we would do a little bit of digging and then say, okay, no, we don't need an internal investigation, but then some did rise to the level of investigation. And then external audits too. So sometimes auditing a company, if you're auditing your third party intermediaries, your JV partners. I've seen one come out of an audit that we conducted of a distributor in Mexico, for example. So yeah, those are typically the ways that we see internal investigations triggered from the in-house perspective.
And one of the things that you mentioned, and I think is really important, is the hotlines. You can be anonymous. Like you said, they're helpful sometimes because if they're specific enough, you can investigate. The problem that I found with anonymous hotlines is that when I was in-house, we would get anonymous tips and then we'd investigate, but there was nobody to follow up with for further questions because there's no means, if they're anonymous, to, have an interview with them or ask further questions. But sometimes, and you probably see this, Stephanie, sometimes the people would follow up and to be disappointed or report anonymously again on the hotline that they were disappointed that the investigation didn't reveal any misdoings or other things. And so it's really, again, I get why people are anonymous on it because, sometimes I think they think that there's going to be retribution or something. But for those of you that are watching this and in various functions, think about that if you whether you really want to be anonymous, because it's hard. Again, if there's no further facts, it's very hard sometimes if you leave very basic details about some wrongdoing, then almost impossible, especially at a big organization. Sometimes there is so vanilla that it says, my coworker, is not showing up for shifts or whatever. Okay, like how do we even investigate that? How, we can't really do that. So in any event, Braden, Stephanie talked about the internal ways that these things are triggered. From external counsel's perspective, are there any additional triggers for internal investigations that you've seen or that you can think of that share with our audience?
Yeah, there certainly is. I'll get to that in a second. Really quickly, just on that point of reacting to the in-house aspects of it, I think best practices is to have an anonymous tip line and to have obviously policies and procedures that explain when and whom you should report, certain behaviors to, in certain events and things that you've witnessed. It needs to be broad enough that you allow for some subjectivity. You want to get more tips and more escalation than less. You want people to feel comfortable doing that, feel like there's an open channel of communication. Not everything needs to be a smoking gun, right? You have to understand, these folks across the organization are not equipped with the tools to identify what is material and what rises to the level of something that should trigger a huge internal investigation or a very small one that can be handled in-house. And that whole process is what you want to ferret out. You want to ferret out the right decision. And sometimes outside counsel gets brought in and it's like, you know what, this is actually not that big of a deal. I think in-house counsel can actually handle this. I think this is what you should do. if things blow up from there, call us, then we can do something. Because there's so many different iterations of how an internal can get done, which I'll get to in a second, which is based on the triggers from the outside counsel standpoint. But on you know, if you're listening to this and thinking about, you know, when do I submit something anonymously, you know, or if I only feel comfortable submitting it anonymously, definitely do not feel discouraged from doing that. Try to include as much information as you can to assist folks in, because I understand the idea behind it, right? It's a lot of pressure to be the single whistleblower on something that's going on. And it is almost never the case that only one person has knowledge, information regarding this issue, right? But sometimes it does take one person who is willing to raise their hand, right? And it's a lot of pressure to kind of be that sole person and carry it all the way through. And if there's enough information provided, you can typically identify a department, you know, and then several people within the department who can be helpful custodians and witnesses. And then you can build out the story from there, depending on how severe the allegations that were raised at the outset, right? So, you know, we've mentioned, you know, different kinds of whistleblower tips, right? That could come from, you know, an employee, that could come from a vendor, that could come, you know, from, you know, a third party that's involved, a contractor. You know, it's often the case, very, very often the case. The number one trigger is regulators, law enforcement, regulators, someone from either the government or a self-regulatory organization like FINRA, right? That's the number one trigger that I've seen. You know, with the exception, it depends on the company. If it's a smaller company, right, it may be kind of an internal whistleblower or just a complaint, right, that gets raised up through the ranks. But the really big ones that have the most consequence, you know, typically, you know, it's a regulator coming in first. That goes back to why internals are so important in the first place. That's going to be a huge part of it. If the regulator is the one who raises this, and this is what gets the company thinking about this issue, then, I mean, the number one thing that we're going to be looking at, aside from exactly what happened and figuring out whether there's a violation of law or a rule, or company policy, or all three, it's going to be who knew what, when, and what did they do about it. And if it becomes the case, which it is almost, I mean, it is very often the case, that somebody knew, who was relatively senior at a period of time where something could and should have been done about it, right? And in the case where it should have been self-reported, you're going to add a tremendous amount of potential liability there. It's going to be very difficult, you know, to, you know, on the cooperation side, right? If you didn't kind of have that corporate hygiene early on to say, hey, we saw this as soon as this came up, we flagged it, because it can become an exercise. It's almost showing off, right? Having a bad thing happen is not the end of the world for the company. It may be a very difficult event for an individual or a group of individuals, but for the company, this is an opportunity to really shine, right? And show this is how we deal with complex issues internally when they come up. We address them head on. We had a great culture where somebody raised something up the chain. They felt comfortable because of the culture that we have, right? I can't name company names, but we all can think of companies, you know, in the last decade who have been put on display through congressional testimony, examples of poor company culture where people do not feel comfortable, and for good reason, right? There's a lot of rules surrounding whistleblower protections and things that we do to make people feel comfortable coming forward. And so if there's an opportunity to really show, hey, this issue came up, we dealt with it, we determined that it should be self-reported, we self-reported it to these entities, here's what we did in terms of remediation, you know, here's all the things the steps that we took. You know, oftentimes there's not what is a regulator going to do at that point, right? Like oftentimes there's situations where you can have a regulator just walk away and say, great job, right? And in other cases, right, where the government has to expend a tremendous amount of resources, data to identify it, you know, it's frequently the case that a whistleblower or complainant tried to raise something with the company, nothing happens, they go to the regulator has to step in. it's just not a good foot to start out on. And so, I would say some other different ideas. We talked about data breaches. That's 100% an example of something that triggers, a type of internal investigation that I've been involved in, but it also triggers experts in that field, right? So depending on what the core subject matter is, right, whether it's data privacy, whether it's securities, which I have a lot of experience in, depending on what that issue is that turns on a rule, there's other subject matter experts that may be brought in to weigh in on that part of it. It could be threat of litigation, right? Or a litigation that's filed, right? Adverse media reporting, which we've talked about, which we've seen some examples of, right? Executive misconduct. I would say that's one of the biggest things that people don't think about, and mistakes get made. In terms of situations that end in protracted litigation that costs tremendous amounts of money, way more than it would have cost if it was met head on with an internal, is executive misconduct. Executives who are high-powered people, who are really important to the company, who have really senior roles, and issues happen, and the company just decides, because they know what happened, right? They've been told, they feel like they have enough, we'll call it evidence, right, to say, all right, you're out of here. We're going to terminate you. We're going to terminate you for cause. And I think that's one of the biggest mistakes that can be made, right, is if you reach out and you have, let's say, employment counsel on retainer that you use frequently, employment counsel can be great. And some firms have tremendous employment counsel that is experienced with actually running investigations, but there's it's really a different practice area, right? When you talk about actually doing an internal investigation, right, reporting either to the board or a special committee, and working through those issues that way. And so if it's not handled exactly the right way, you're opening yourself up to litigation. You're going to pay a huge severance. You're going to work through all this stuff. And often it ends up becoming more expensive and messy and public and kind of a big mess, right? When, oftentimes if you handle this thing with an outside person or outside firm coming in, you can settle this quietly, much more quickly. You can avoid litigation often in these circumstances because you can have more of an open channel, kind of private settlement negotiation with the other side, and they can also feel a lot better about the process, right? Sometimes that process ends up in, well, it's actually not true what those allegations are. We actually dove all the way into it. We don't need to litigate for 3 years to talk about it, right? Actually that didn't happen, right? But if we feel like there's not a good culture fit, you don't need to terminate this person for cause. There's not that requirement in the employment contract. So if you want to let them go, don't let them go for no reason, not cause, and we can avoid all this litigation, right? But yeah, that's kind of the other side of it that I tend to see.
Thank you. And we're not going to spend much time on it, but one of the things that I think you hit on, Braden, is that there's a memo from the Department of Justice known as the Thompson Memo that's been modified 6 or 8 times over the last 20 years. And one of the things that it really focuses on is kind of what you were talking about, having a good internal system, having a good policies and procedures, having it will deflect or diminish what corporate penalties, including fines and penalties and other penalties, if you have a robust system. And again, I think both you and Stephanie have talked to kind of having this kind of internal system, and it's not just having it, with the Enron was already mentioned. One of the things that was seen with Enron back in the day was they were on the cover of Fortune or Forbes, I think, at one point in the late 90s, as the most ethical company. They had a no tolerance policy. They went out and touted it. They spoke it. And then when the onion was peeled back in terms of what took place there, it was tone deaf from the top, not tone from the top. And so I think that's important. So that's a good introduction. We're now going to turn to some of the process and framework of the investigation, and Stephanie's going to take us through, if you would. the framework of an investigation and kind of the steps and what it looks like from your perspective?
Yeah, sure. So typically when a report or an allegation comes in, the first thing we will look at is what is the problem that they're reporting? Because you'll need that to define what the scope of the investigation will be, if there will be an investigation, if it rises to that level. So Braden touched on it a little bit before. What policy, what company policy has been violated, or what law, violation of law has occurred? Because then from there, then we start taking a look at, okay, what is the risk here? Could this type of allegation affect our financial statements? Are there officers or senior executives involved? Will, if the allegation became public, would it damage the company's reputation? And then is there a likelihood that the allegation will become public? Are regulators involved? All the sorts of things that Braden was touching on before. And then from there, we will identify who within the company needs to know. So assuming that the matter has been escalated appropriately, depending on the company, that it could vary on who that would be. Typically, it's the legal department. Sometimes we have an ethics and compliance group that is also well-versed in these types of matters. But then we need to identify, okay, who else needs to know? Do we need to let the general counsel know, the executive team know? At certain companies, I've seen where certain committees of the board will want a debrief of whatever the allegation is, and then they'll want to be briefed on status updates periodically as well. So once you've done all that, then the next step there is to prepare a plan. So typically that involves identifying who you will need to interview and what order you will need to interview them. Sometimes there's justifications for scheduling interviews in a certain order at certain times on certain dates, sometimes back to back, so you're not giving people a chance to talk to each other. It really just depends. It's so fact specific, but those are the sorts of things that you want to plan ahead of time in advance. As well as what evidence you're going to need to collect, where the data sits, who has the data, all those types of questions you'll start to think through and plan out. And then as well as what processes you need to take to preserve evidence. And so in the same vein, once you've figured out what type of data or documents you need to collect, then you'll need to start thinking about how to preserve it. And so usually that will come in the form of a litigation hold. And typically, when things start pointing towards the possibility that there might be litigation, which sometimes that happens up front, and sometimes it doesn't happen until you start digging in a little bit. So it kind of just depends. But once that, so it could be that, or, you get a notification or a letter from the government saying, hey, we're investigating this, like Braden mentioned. Or, you start digging into something and you start seeing, oh, okay, this is potential legal action will result from this. And so then you just want to make sure that you are preserving the data that you will need. And so that can be emails, PowerPoint presentations, Word documents, spreadsheets, voicemails, photographs, videos. It can be all kinds of different sources. And then who is most likely to have them? So who within the company has that information? And then the litigation hold that you send should also go to, typically we also send it to IT to make sure that sometimes there are like auto destruction rules set on either email, so like delete certain emails or all emails within, 30, 60, 90 days. So you want to make sure that IT is aware of the holds so that they can stop any of those things that are set on auto, as well as HR. So if any of the custodians that you identify who might have some of the data, if they resign or they're terminated, so HR knows to notify you that. And then maybe I wouldn't say the last thing, but one of the last big piece that we look at in this, the framework of getting an investigation in and how to handle it is, and Braden touched on this a minute ago, when we should assign it to outside counsel. And this, it can be tricky to figure that out. So, I mean, it really just comes down to the complexity of the matter, typically the complexity, the subject matter, and the location where it is. So there are times where certain locations, if a matter comes in from, and it's of a certain topic and it's in a certain country, we sort of automatically know, okay, just based on experience and based on having seen these types of matters come up before, we know, okay, we really need to bring in outside counsel. And so most companies will have certain firms engaged in different countries. So I think a good example of that is in Australia. So Australia has very expansive whistleblower laws. And so if an employee raises a certain, what they consider a disclosable matter, they can qualify for whistleblower protection. And so then we know, okay, we're going to have to follow a very specific process for during the investigation to make sure that we don't have any procedural issues down the road. And so in those cases, we pretty much always say, okay, we need to bring in our outside counsel. And that will help us, even though sometimes we don't necessarily hand off the entire investigation to outside counsel, let's say in Australia, but we'll do sort of like a hybrid where if we have a seasoned investigator in-house, we'll say we'll conduct the investigation, but with the guidance of outside counsel. So we're not giving it all to them, but we'll ask for guidance. And with experience, you kind of start to learn the process yourself, but we'll ask for guidance on procedural issues and how to address certain issues with outside counsel.
So it sounds like you would caution against, shoot, aim, fire, right? Or fire, aim, shoot, right? It sounds like there should be some deliberation on the part of the people that are running the investigation before really triggering the next steps, right?
Yeah, I think
Yeah.
so. I think that's probably one of the most important parts that can save you a lot of trouble down the road if you think it through at the beginning.
Yeah. And again, before I turn it over to Braden, one of the things that I experienced a few times, both as outside counsel and in-house counsel, is sometimes you'll have different constituencies within an organization may have their own counsel or their own kind of advisors, especially if it's something that comes from the SEC and it's an investigation, say, of the CEO or some wrongdoing. Sometimes the board will want a separate counsel, right? And or their separate own kind of guidance. And as an in-house counsel, it's kind of puts you in an interesting role, right? Because you're trying to be objective in both of those arenas because they're asking you for guidance on how to handle it. So it can be a challenge of coordinating that as well. So something to keep in mind. So Braden, Stephanie talked about kind of the internal piece and say that the company tries to gloss over the damage a bit, keeps it in-house, but then realizes the problem was more than they could handle. So they decided to bring in outside counsel. What happens next to contain the damage and proceed with the investigation and pick up the pieces of where it's at currently? And it may be, it's at a stage where it's not a good sign. So kind of walk us through that.
Yeah, and I mean, it'll sound biased, but it's almost always the case that it is the best practice to engage outside counsel. It is, there are some circumstances where a company is sufficiently sophisticated and has the resources in-house and the experience in-house to know the first steps and know kind of the framework of the initial things to think about and how to respond to that, right? And can start to at least get a hold of what's happening. But it is almost always the case that that's the situation in which outside counsel gets involved, right? It's never early enough. If you're outside counsel, right, it's never early enough, right? It's always like, man, I wish you reached out 2 weeks ago. Sometimes it's 3 days ago, right? Because you can't put genies back in the bottle, right? One of the main issues.
It's also, you know, not to interrupt you, but it's also what I always say that outside counsel is we're parachutists, right? Because we jump in and so we don't have full facts even, you know, that's the other probably you'll probably get to, but we don't necessarily have the full picture because they don't want to spend money for you to get up to speed, right? So you probably have that problem as well getting in later.
Well, I think that's part of the beauty of that dynamic, though, because outside counsel is completely objective, and we're like, well, there's 10 decisions that need to be made in the next 48 hours, and there's a list of information that we need to have to make that decision. And oftentimes, you know, without outside counsel involved, right, you just don't have all, even in-house, right, will not have the answers to all of those different items, right? And it's like, oh yeah, well, we don't have that, and we didn't do that yet, right? And I think, I mean, the first thing I was going to say is, you know, there's privilege, and I think just maintaining control of the process, right? Because oftentimes when there's a big crisis, you know, it depends on how private this is. If you got a letter from a regulator and no one really knows about this, it's not in the press, you know, not many people in the organization know, but for a select few, that's a situation, right, where you can roll your sleeves up and get and dive in, and there's not a lot of consequence to a week delay or 2 week delay. But in other circumstances, there's something pretty public that happened that spreads like wildfire across the organization that people know about, and people are talking about it. We're not maintaining any sort of privilege on this. Sometimes that's helpful from you know, from the perspective of, you know, trying to figure out what happened and figure out who is the culprit or what's going on, because it'll produce communications reacting to what occurred that then gets collected and reviewed. You know, but we would much rather be able to come in, preserve privilege, you know, figure out who we need to talk to, you know, ensure everybody's, you know, complying with, you know, both the law and internal policies, you know, and start gathering facts. But it kind of depends on the situation, you know, what needs to happen first. You know, if there is a risk of kind of public disclosure, you know, I mean, depending on how publicly facing the company is, you know, I've dealt with issues representing sports teams, you know, or professional sports leagues, where it's very public. If something like this gets out, there's a lot of public interest in what this company does, and you know, it can be pretty devastating if you don't have a, you know, a response plan, right? So you know, in addition to the internal investigation team working on the fact gathering and analysis and interviewing witnesses and reviewing documents, and advising the board, you know, on kind of the investigative aspect of things, you know, oftentimes you'll also engage a PR crisis response firm, you know, whether, you know, some law firms have that in-house. You know, sometimes you would engage in additional, you know, call it a fourth party, right, to think about that and actually have it pre-prepared, right? That's very common. You have something pre-prepared. We don't want this to leak. We don't think it's going to leak. We're going to do everything we possibly can to make sure it doesn't. But if it does, this is what we're going to say. This is how we're going to respond, right? And you're prepared for that. You know, I think the initial kind of steps here with the plan is like, okay, what is the core problem? So it's scoping, because you want to boil the entire ocean, right? So what is, you know, we got to define the scope of what this investigation is going to be focused on. And sometimes you don't have that enough information to properly scope yet. So, you know, maybe the question is, what do we need to know? You know, maybe there's some initial, that's a very common thing, right? So before, it's typically the case that the most helpful, let's say 30 interviews that you're going to do, in a real internal, it's very common first to speak with 3 or 4 people who, seem like they're really important. You haven't reviewed documents yet. You don't have context yet. You're not fully up to speed yet. But those initial kind of, let's call them it's not a full forensic interview, right? It's not a full forensic, substantive interview. This is kind of like a pre-interview, right? Where we're just getting our feet wet. We're just starting to understand the landscape and who would be good custodians, right? Sometimes out of those first 3, 4 people that you do a pre kind of initial interview with, maybe 1 or 2 of them weren't helpful at all, but they were able to point you in the right direction, and you're able to go from there and start figuring out where you're going to scope this, who the proper custodians are going to be. You can start to understand. I think talking to head of IT or the chief information officer about, okay, what are the data sources that the company uses? What are the mediums and platforms that employees talk to one another on, right? Who was involved in this process at the company, and just like starting to understand that from a 1,000-foot view, and then figuring out, because you don't want to go in half-cocked, right, and not have all the information when you're putting together this plan of work. So typically there's a little bit of dipping your feet in, and then you put together the plan of work, after 48 hours, 72 hours of initial pre-work. You have a little bit of a better idea of, okay, this is what we're going to do. This is what our plan is. We're going to talk to these people. We're going to collect these data sources. If it's a heavy, deep, financial kind of fraud, or it involves heavy amounts of financial data, is there forensic team on that we need to bring in on that side, from one of those types of vendors to engage on that side of things. And then establishing kind of a timeline, right? Like that is often one of the biggest throttles, for cost, right? You throw more resources on an internal, you can get it done way faster. Public companies, because of the reporting and disclosure obligations, tend to want to move extremely fast. And there's also much more kind of outside risk of leaks and reputational damage and the stock price. And, there's a lot of considerations there when you're thinking about protecting shareholders and making sound decisions as a board of, what's going to be the timeline? How quickly do we need to get an answer and decide? You may have a difficult situation where you have an 8K due in 2 weeks, right? And you may have to put a placeholder, right? And that's going to create some hoopla, right? In an ideal world, you have enough time to complete the investigation before your next big kind of, material disclosure. And instead of just disclosing the existence of an investigation, right, or a potential issue, you can actually have some answers, right? And so that would be the first thing is that, and then thinking about protocols for communication on the progress, who are you going to report to? It almost never makes sense, internally, it's so hard to figure out who can really be involved. If you have a whole department that does this sort of thing and they're completely divorced from the operations of the company, all the different ways that the company makes money, they're way over here, then that can help. But you don't want to have in the reporting line somebody who you find out later is actually a witness, who was actually in meetings, was actually on email chains, and you're like, oh, it's a little bit of a nightmare. And so I think from the standpoint of protecting those people, whether they are in HR, whether they're in compliance, whether they're in legal even, and certainly on the board, kind of helps to be able to lean on outside counsel to be able to navigate through that situation. Because you can rely on that, right? You can rely on outside counsel making that determination, and as a board say, we just followed this advice that kind of insulates you.
Great. Oop. Oops, sorry about that. A lot of noise here. I don't know what they're doing right now in the airport, but it's good that
We
it
can't
finally.
hear it, so you're good.
I was on mute, so it stopped. Can you discuss briefly the process utilized for collecting and preserving evidence from the outside perspective?
Yeah, so initially it's like what are the data sources, right? So and that can be different depending on the company and what people use. I've seen it all at this point, whether it's Slack, whether it's Skype, whether it's Teams, how are people communicating? Obviously, email is the easy one. But there's little things to know, right, in terms of the e-discovery aspect of data collection. It's a web, right? It's a web of understanding what are the tools that are best utilized to collect this type of data versus that type of data. You can start to figure out what teams that you're going to need to put in place to collect that data appropriately. Slack has been, a funny thing. There's a lot of these instant messaging platforms that have been a little bit of a headache, for both regulators and outside counsel to navigate how to best collect this stuff. There's privilege issues, there's issues because some of these modern platforms for communication, they're just like simply not designed for forensic collection. They were not designed with that in mind. And so if you're a company in a regulated industry, but of course, even if you're not, right, it can still become, a really important thing to think about, right? With Slack, you have people can jump in and out of these channels, right? So you pull an attorney into the channel on launching a product, and they're in there for a little while, and then they dip out of the chat, right? And the conversation keeps going. It'd be nice to be able to say that this whole channel's privileged, but it's not. And so that can become a very manual effort, right? And so I think starting to think through what the data sources are first, and then from there, right, that's where the lit holds come into play, right? So you're going to put a manual kind of institutional hold wherever you can, right? Wherever IT can come in and say, you now no longer have the ability to delete, that's what you want to be able to do. Historical kind of, legacy established, platforms provide various measures to be able to do this. And literally prevent. You can just click a button. Now nobody can delete things. None of these custodians, and initially while you're selecting custodians, nobody can delete anything. We're going to preserve literally everything, and we're going to remove the ability to delete, either for this period or until further notice as you start to wrap your arms around this thing. So thinking about for each source is so important, because how you go about doing that is different depending on what the data source is. And then, of course, it comes down to custodians, right? Like, thinking about, no one likes to talk about this, particularly, off-channel communications and all that kind of stuff. If you're a regulated financial institution, there's a lot of consequences, potential consequences for off-channel communications and the like. And the reality is, in most companies, there are off-channel communications happening, right? And so, thinking through those issues and thinking about, okay, how do we make sure that we're capturing everything here and we know what's going on? Are there people texting? Are there people, having, off-channel communications that are not going to be captured by the investigation that we're doing? How do we navigate through that? How do we feel comfortable, as a company, navigating through that? And you can think about even paper documents. It's less of a big deal today, but people do maintain paper documents and notes and scratch pads, and that can be a source of collection as well. That can be kind of tricky, but I've dealt with that, right? Where you have boxes and boxes of paper documents that have not been uploaded to the cloud yet, don't exist anywhere else, right? And you actually have to go through and scan those in, and discover those. So, I think the next piece is you think about review, right? So once you identify the data, where do you go from there? I think you got to see what the scope of this data is. After you've whittled it down, you've done some of these pre-interviews, you've figured out, okay, and even some pre-review. So like you can't even really come up with a plan on review until you've done some pre-review. You got to get in there, right? And figure out, based on what you're seeing, what are going to be the exact what's the exact terminology people are using? What are the acronyms people are using? What are the different patterns of language that people on the team are using to describe this issue? That's the core, point of this investigation. And use that to backtrack and then figure out, okay, we thought from this interview that the timeline was this, but we actually found documents critical to this issue that actually pull the timeline back or move the timeline forward, right? And so you got to trust but verify, right? It's helpful, to have these pre-interviews because it can tell you where to look first and where to set the boundaries, but you actually do still have to go in and do a little bit of, digging around as I call it, right? In a pre-review kind of standpoint before you've set the whole thing in motion. Through that process, you can come up with kind of an established timeline that everybody feels comfortable with. You can have that conversation with the company. There's typically different options. Hey, this would be more conservative. This would be more aggressive. Let's figure out what we feel comfortable with. Let's talk about what the differences in costs would be. Let's talk about the pros and cons and the consequences of potentially not having this thing broad enough to begin with, right? Because there's a difference between a timeline and a set of search terms that you're going to run through this data and a culling process that is going to be suitable for preservation in case a regulator comes in. That needs to be highly conservative, but there's a difference between that and what you're actually going to go review, right? And so there's pros and cons to how much you're going to review at the outset. It's sometimes nice, especially if you're anticipating that a regulator is going to send you a subpoena right after. Maybe they are already aware, maybe it's going to be later down the road, but it would be kind of annoying to have to go back to this data set and do another review of an expanded timeline that you reasonably could have predicted that the regulator would want, right? And have to start backtracking and starting a process over. It's going to cost likely more money and be annoying. And so once you identify it, I think you have this kind of population that you've set on, this population of data, right? That's critically important. Identifying the key categories would be kind of my next phase, right? What are the core different categories of issues, right? Issue 1, issue 2, issue 3, issue 4. What are going to be populated as on the coding panel as issue tags for reviewers? What should reviewers be looking for? I think the digging around pre-review is critically important to that phase as well, because from the top, you have to be able to set the standard of exactly what folks should be looking for on review and have examples. You should have core critical examples and several of each of the different issue categories that you want reviewers to identify. And you should also have examples of what would be a key document. What would be considered a very key document, a very interesting document, right? Well, people use different terms to describe that, but essentially a document that moves the needle on this investigation, that tends to support or not support, prove or disprove the allegation, or the critical theory of whether there's a violation of law or rule, or potential liability on a specific issue. And based on that whole process, who should review this, right? And how many people? That again factors back into the timeline. If we have a 3-month timeline and we have 1 million documents and we cannot call it further. We had 5 million and we called it down and we called it down and we called it down, and there's just no way around it. We have 1 million documents to review. That's not going to be something that outside counsel is going to review, line by line, right? That's going to be something we're going to bring in contract attorneys, right? I've brought in as many as 300-400 contract attorneys at given times, you know, and that's difficult. That's a lot of people. That's a lot of people stationed, you know, often all around the country. And, you know, so what's going to be the training process? How are we going to train these people in relatively short order and also give them the support to make sure that the client is actually saving money by having contract attorneys do this? They're much cheaper by the hour, but we got to make sure that we catch their mistakes, that they're properly trained, and that they deliver good work product. And right, and so you'll have second level review. You know, you'll make sure that you're QCing that and escalating documents and putting together that chronology. Right, that's kind of the one of the core work product that is created from an internal investigation. It's the entire story of what happened in a chronology that you know, that tells this chronological kind of timeline of exactly what happened, who was involved, and what is the key document that is associated with that event. Using that, you can kind of create all different types of other judgments and other work product. And then yeah, and then I would say, yeah, and then the next piece is like any other forensic consultants that might get brought in at that point once you have some of that data, you've collected some of that data.
Thank you. Yeah, Stephanie, how do you ensure that you execute an investigation with objectivity?
So I think sticking with the scope that you set out at the beginning of the investigation. So oftentimes investigations can try to expand, or let's say the people that you're interviewing can sometimes, I've seen interviewees try to deflect by saying, oh, well, I have X and Y, Z issue, or I have this other complaint, and or I know this about some other person. So often there's a fine line, I think, between additional information that you get from interviews that is relevant to the scope of the investigation, and then sometimes just based on experience, you can tell where, you know, it's more of just like a deflection tactic. So staying focused and not letting you distract you from the scope of the actual investigation, I think, is the first thing. In terms of when you're conducting the interviews, of course, typically these interviews will start with the upjohn warning or instruction that we have to give. And so doing that in a way, though, that is conversational and doesn't immediately put employees on alert, or whoever you're interviewing on alert. And then generally starting with very broad questions and moving to more specific pointed questions. So sometimes I've seen that the order in which you ask questions can be important, and paying attention to that can sometimes make a difference between whether you get certain information that you're looking for out of someone you're talking to versus you know, asking the wrong question right at the top and risking the person you're talking to kind of getting defensive and just shutting down completely. And so I think that can help a lot too. And then you know, just remembering that all of your questions should be that the purpose is to get to the facts, right? To collect the facts. And so taking out any bias in even the way that you ask questions or the tone that you ask questions in, it can also make a big difference.
You get the last word. Any takeaways or best practices for listeners that they can listen to? And if we have time, Braden could chime in as well.
Yeah, I mean, in terms of best practices, I think maintaining your independence as an investigator, especially, I think it's a little bit easier when you're outside counsel and you're, you know, you don't know any of the people involved. And depending on the size of the organization, if you're in-house counsel, it's a little bit easier. If it's really large company and you don't necessarily know all of the players involved. But just maintaining that independence is really important. I think the planning phase, like Brandon touched on a minute ago, is really also important. I think, like anything, the more that you think through all of the different avenues that an investigation can go and try to prepare for it ahead of time, while maintaining a level of adaptability and being able to pivot when you need to. I think that's also super important.
Yeah, and I would just add, like, we didn't talk a ton about interview process, but you got to upjohn people. You got to make sure that employees know that you represent the company, and that you don't represent them individually. That's always a somewhat sensitive, depending on how senior the person is. The more senior they are, the more they tend to kind of ask questions about that, be very interested in that dynamic, and often and sometimes choose to engage their own counsel. I think sometimes that can look like a red flag, but oftentimes it's not. It's, just, wanting to make sure that you have your interests protected, but sometimes that can slow things down, right? So I think navigating that process, and I think wanting to avoid situations where someone who's not a target at all, feels that this is some adversarial thing, right? There isn't a conflict until there is, right? And so, the upjohn warning is just saying, hey, listen, we don't see a conflict right now, unless you do, right? But we don't see a conflict right now, so we don't see an issue. But right now, we represent the company, right? And at some point, if there's a conflict, we'll let you know. And sometimes that happens. I mean, that sometimes that happens, and then at that point, they're able to engage their own counsel. But I think that's an important part. And I think, this is about making great decisions, right? We talked a lot about reviewing data and interviews, but this is about, assisting the company in making sound, defensible decisions that will stand up to anybody else looking in, anybody else who down the road is trying to play Monday morning quarterback on what you did, the decisions you made, and what happened at the company. And so that needs to be at the forefront of everybody's mind throughout the process. And I think the more candor that you can elicit from witnesses, and the more credibility that you're going to have down the line as you give your recommendations to the board and to the executives of the company, and make those decisions to whether to have conversations with regulators in the future.
On behalf of all attendees, I want to extend a gratitude and thanks to our excellent panelists, Braden Anderson and Stephanie Bustamante, and look forward to seeing you again soon. And hopefully you got a lot out of this, as I did. Thank you, and have a great day. And if you're watching live, we didn't get any questions, so we thank you for watching.
Thank you.